Start. Para. It is well settled that while exercising appellate powers, especially while dealing with appeals against acquittal, cardinal principle to be kept in mind is that there is a presumption of innocence in favor of the accused unless the accused is proved guilty. The presumption continues and finally culminates into a fact when the case ends in acquittal. The possibility of two views in criminal case is not an extraordinary phenomenon. While considering appeals against the acquittal, fact cannot be lost sight of that the trial court has appreciated the entire evidence and reversal of an order of acquittal is not to be based on mere existence of a different view or mere difference of opinion. Normally, while exercising appellate jurisdiction, it is duty of the appellate court, whether decision is correct or incorrect on law and facts. While dealing with appeals against acquittal, the court cannot examine the impugned judgment only to find out whether view taken was correct or incorrect. After reappreciating oral and documentary evidence, the appellate court must first decide whether trial court's view was possible view. The appellate court cannot overturn acquittal and order of acquittal cannot be reversed only on the ground that after reappreciating evidence it is of the view the guilt of the accused was established beyond reasonable doubt. Para. Learned counsel for the accused pointed out from the evidence adduced that the demand and acceptance sine qua non to prove the office is not proved. Mere recovery of money itself is not sufficient to establish the guilt of the accused. There is no corroboration to the evidence of complainant PW2 Vilas as shadow puncher. PW1 Suresh specifically stated that there was no demand and it was the complainant who handed over the amount to the accused. This evidence is to be appreciated in the light of the admission given by the complainant that he contacted the accused and informed him that he would pay the amount and prosecution should not be launched. This evidence is sufficient to rebut presumptions. Para. The Honorable Apex Court in the case of Yan Vinay Kumar versus State of Tamil Nadu, as cited by learned counsel for the accused, dealt with expression erroneous, which means wrong and incorrect, and observed that it will be necessary for us to emphasize that a possible view denotes an opinion which can exist or to be formed, irrespective of the correctness or otherwise of such an opinion. The correctness or otherwise of any conclusion reached by a court has to be tested on the basis of what the superior judicial authority perceives to be the correct conclusion. A possible view, on the other hand, denotes a conclusion which can reasonably be arrived at regardless of the fact where it is agreed upon or not by the higher court. The fundamental distinction between the two situations have to be kept in mind. Para. By applying the aforesaid principle and the evidence on record in the case in hand, I am of a considered view that the view taken by learned judge of the trial court is a possible view. As far as applicability of presumption is connected, the Honorable Apex Court in the case of Nirja Datta versus State of Government of NCT at Delhi Supra held that presumption of fact with regard to the demand and acceptance or obtainment of an illegal gratification may be made by a court of law by way of an inference only when the foundational facts have been proved by relevant oral and documentary evidence and not in the absence thereof on the basis of the material on record. The court has the discretion to raise a presumption of fact while considering whether the fact of demand has been proved by the prosecution or not. Of course, a presumption of fact is subject to rebuttal by the accused, and in the absence of rebuttal, presumption stands. Stop.